I'm trying to find the right file. Good morning.
Yes, good morning, Chair. Good morning, Commissioners.
Which one should I have?
It's Kefelakai.
Apologies for that.
No, thank you, Chair.
Yes.
Chair, we are ready to resume. Just for the record, we continue with the EMPD stream. However, today and in the next coming days, we will be dealing with IPID witnesses, but insofar only as EMPD is concerned.
Do you want to place on record who's assisting you today?
No,
Not that we don't know the face.
okay. It's from the Commission's attorneys, and he is sitting by me to assist me with technical aspects of dealing with this witness. It's our usual attorney.
Good morning to you too. Thank you.
As I was saying, Chair, the witnesses we'll be dealing with today into the next coming days are from IPID, except their testimonies will be confined strictly to Ekurhuleni. We are aware that we still have what we call the IPID stream to run, and the fuller IPID picture and stream will run in the fullness of time. But for the next 3 days, we are confining ourselves to Ekurhuleni. With those remarks, Chair, the witness is ready and ready to be sworn in. It's Mr. Thuso Kefelakai. If the Chair could swear him in, please.
Good morning, Mr. Kefelakai.
Good morning, Commissioners.
So you don't enunciate the second E, does it? Can you please pronounce the surname?
The surname is pronounced as follows: Kefelakai.
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 Yeah, Kefelakai.
Perfect.
I did not hear you pronounce the second E. So that's why I was suspicious and wanted the witness.
I was hoping you had missed it, Chair.
Thank you. Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you very much.
Thank you.
Thank you, Chair. Mr. Kefelakai, you should have before you 2 small white files.
Correct.
If you look at the spine of each file, you will see that the one has got your name and is marked statement, and the other is marked annexure.
Correct.
So if I want to refer to any one of the 2, I will say we are going to the statement file or to the annexure file. So I would invite you now to go to the statement file, please.
I have it ready.
Do you confirm that you have provided a statement to this commission for purposes of its inquiry?
I can confirm that.
Please open the file marked statement and look at that document. It has at page 1 in the trim lines your name. Is that, and it's a 25-page document with a signature and a date at the end at page 25. Do you see that?
Yes, I see that.
Do you confirm that that is the statement you provided to this commission?
I can confirm, Commissioners, that this is the statement that I've deposed.
And do you stand by the contents of the statement?
Yes, I stand by the contents of the statement.
Thank you. Can I invite you then to page 1 of your statement?
Correct.
And your first chapter there is an introduction about yourself. If you could introduce yourself without necessarily reading out your personal details as reflected therein.
Thank you, Commissioners. I'm the Director, Investigation and Provisional Coordinator of the Independent Police Investigative Directorate. We are based here at head office at 473 Stanza Bopape Street, Arcadia. I am currently serving as the IPID, Acting National Head of Investigation, with my PESAL here, 6339875.
Okay,
you.
that's the part I didn't want you to read out.
Okay.
But noted. Before we continue, perhaps just to put into perspective, Chair, Mr. Kiafelagai's testimony, the commissioners will note that he deals with the legislative context and IPID mandate. But that is only in brief and in passing, and soon thereafter, his statement concentrates on the Gauteng region with the eventual focus on Ekurhuleni. So that is how the evidence will run, and we'll not be talking in large part about any other area in the country except Ekurhuleni. With that background, then, Mr. Kiafelagai, you have the next chapter headed Legislative Context and IPID Mandate and the types of matters that must be investigated. In this regard, you make reference to particular sections of the IPID Act. So if you could just quickly talk us through that.
Thanks, Commissioners. I'm going to read just this part, and when I come to the Section 28, subsection 1 of the IPID Act, I'll just talk to it without reading word by word. The legislative context and IPID mandate. The IPID is a national body established in terms of Section 206, subsection 6 of the Constitution of the Republic of South Africa. The operational requirements of the IPID are provided by the IPID Act, Act 1 of 2011. The Act empowers the IPID to play a crucial role in promoting transparent, accountable police in South Africa by investigating serious criminal offenses and misconduct by SAPS and the MPS members. Now, talking to the MPS, just to put the context there, is the Municipal Police Service that relates to the Metropolitan Police Departments. Now, with regard to the types of the matters that IPID is responsible for, you see there in paragraph 4 is in terms of section 28, as I've indicated, that relates to 4.1, which death in police custody, death as a result of police action, any complaint relating to the discharge of an official firearm by a police officer. And also we deal with matters relating to rape by a police officer. It doesn't matter whether that police officer is on or is off duty. And then we also deal with the matters relating to any rape in police custody. And custody would mean that when the person is in control, or rather the police are in control of that person. And any complaint of torture or assault against by the police officer in the execution of his or her duties. And we also deal with issues of corruption that initiated by the executive director, which means that the executive director has got powers to initiate investigations into corruption, and also the minister, the MEC, and the secretary of police. And,
my apologies, Mr. Kifelakai. Before you move to the next part, going back to your page 2, at item 4.6, I think a correction is required there based on how you just testified. Currently, it reads any complaint of torture or assault against a police officer. You intended to say by a police officer. Is that correct?
Yes, yeah, so it's by a police officer.
So it's not against, so if I may request the commissioners to make that amendment.
Okay.
Thank you. We are now at page 3, you may proceed.
Okay. So there is this 4.8 that would then talk to section 28, subsection 1, H of the IPID Act. It says any other matter referred to it as a result of a decision by a executive director, or if so, requested by the minister, an MEC, which is the member of the executive council, or the secretary of police, as the case may be.
Mr. Kefelagai, how are you?
I'm good.
Good morning.
Commissioner.
I want to take you back to paragraph 3 of your statement. Are you there?
Not yet. I'm there now.
And let me tell you why I'm taking you there.
Okay.
In paragraph 3, you talk about the SAPS. And then in paragraph 4, you talk about police officer. When I read the SAPS Act, there's a section in that act that defines a police officer to include a reservist. So I just want, when you describe the mandate of IPID, explain to us whether or not it includes investigation of criminal conduct by reservists, and then just touch briefly on police informants. I'll tell you why this is important. This commission has heard that, for example, EMPD officers have been working with reservists and informants, and they've been committing criminal acts while working together. And I just want to understand whether IPID's mandate extends to investigating reservists and informants, where it starts and where it stops. So I've given you that context. Maybe then you can enlighten us.
Okay. With regard to the police reservists, maybe I should start there. At the moment a person is enlisted as a police reservist, he's given the policing powers. And those policing powers, all the policing powers are given to by the minister. So that person has got the powers to conduct all those responsibilities that should be in line with the SAPS Act. So any contravention by the member should be treated as such by IPID, as though this person is the same as the SAPS members that are permanently enlisted. So coming to the issue of...
Before you leave that, does it mean that you have to be a registered reservist, or even if you are just, say you are a trainee reservist, and while in the process of training you commit a criminal act, does that fall within IPID's mandate, or you must actually be registered and appointed by the minister, as you say?
The enlistment process, I think maybe to put it in a better context, it's something that is analogous to your recruitment and selection process. So that person should have undergone all those processes wherein the appointment is concluded. So before that process is concluded, you are not appointed, you are not enlisted. So other processes these processes of recruitment and selection must be concluded. Then we will then regard you as having been appointed. But I also seem to understand the commissioner that this person has been enlisted and the person still needs to undergo certain training interventions, perhaps to uplift his knowledge and expertise so that he's able to do the work in line with the requirements. If the person happens to be deployed, the fact that the person is still in the process of being capacitated does not exonerate him from taking responsibility, because reservists cannot act on their own. They need to be supported or led by those that are experienced. I don't know whether I've put it.
Yes, I think you've dealt with the reservist. You wanted to deal with the other people, the informants.
The informants.
Just briefly.
Yeah. The informants, there is a difference between an informer and an informant. These are two concepts, and I think we should, when I deal with this, it should be understood within their context. Informer, it's someone who would volunteer the information, but in some instances, this informer must be registered and be given a sort of a code, and he has to submit his documents and all of that. That once he has done some work, whether in form of milestone, he is then remunerated. But then you will have this person called the informant. This person voluntarily gives the police the information as and when he gets to know about matters of crime and criminality. And he would then share that information with the police. So he doesn't have to be registered. So that informant may just be for the day giving you information about a particular matter, and then it's positive, you act on it. And you might not be seeing him again because he was just giving you a tip-off about criminal activities. That's all, Commissioners.
Thank you. I think you've answered me, and maybe let me just again for context. We've had evidence in this case where at least one, if not two, informants, people who were regular informants of the police and provided video evidence to the police, were murdered in suspicious circumstances. So I just wanted to be clear where IPID's mandate starts and ends in relation to those people. So thank you for answering those questions.
Thank you, Commissioner.
Okay, thank you.
Please proceed, Mr. Kiafela.
I was on 4.8. I think I was.
That's correct.
All right. Yeah, I was talking to 4.8 that this is in terms of section 28, subsection 1H. These are the matters wherein we receive matters that do not necessarily fall within section 21A to G, but it's any other matter that would relate to include those matters that are of service delivery in nature, and other matters that might not necessarily fall within IPID's mandate, that the executive director might see it prudent that this matter should be investigated by IPID rather than the South African Police Service or the DPCI. If I were to give a typical example so that I give a context, say for instance you have a case against the station commander of Pretoria Central. I'm using Pretoria Central because we are in Pretoria. The station commander of Pretoria Central commits a crime of rape. God forbid he won't do it. And now the matter is allocated to a constable in Pretoria Central, and the rape happens to fall outside IPID's mandate. It wouldn't be proper that that matter should remain within that station because it might not be investigated properly. There might be interference, there might be intimidation, there might be all sorts of things. So the executive director has that prerogative to say, but given the situation, it would be better to have this matter be investigated independently. And it happens often with matters of domestic violence, wherein the wife and the husband are police officers in the same police station. So in that way, to avoid the conflict, we would then consider taking that matter and deal with it independently, but under this section 28 section 1H of the IPID Act. But I also want to emphasize that also the minister.
It's just that that example does not work in terms of your 4.4 though. At page 2. Or am I missing something?
Yeah.
Your 4.4 says rape by a police officer, whether the police officer is on or off duty. So that would already fall within IPID's mandate anyway. So that's why I say that example doesn't really illustrate what you want to illustrate.
Hence I went into domestic violence, contravention of the Domestic Violence Act.
All right.
Yes, Commissioner.
Thank you. Yeah.
And with regard to the minister, I was saying the minister as well may request IPID to investigate a matter. The member of the Executive Council, the MEC, as well as the Secretary of Police, they may as well request IPID to do so. It's legislated, so therefore, it's not a remiss that when we receive a matter from MEC or the Secretary of Police or the Minister of Police, then there should be some outcry as to why the Minister has requested IPID to deal with a particular matter. So I thought I should put this context very clear so that the country needs to understand that we are mandated and there is a provision in the Act. And we also deal with issues of systemic corruption within the police. I'm not sure, Commissioner, as to whether I should just in brief unpack systemic corruption, or is it just adequate?
I don't think it is necessary at this juncture because our primary topic for today in Gurulen is not an issue that really arises. So perhaps upon your return, we might unpack it at that juncture, right?
Okay, thanks very much.
But then before you move to section 29, at your 4.8, you referenced the MEC. Should we take that to be the MEC for community safety specifically, or any MEC?
MEC for community safety.
Thank you. You then may proceed.
All right, sir, before you proceed, part of the evidence that we've had and of matters that the IPID is dealing with relating to EMPD include, for example, theft of what do we call it? Stones, precious stones, theft of precious stones from somebody's premises. It includes that.
Yes.
And our understanding is it has been reported to IPID, and IPID is dealing with that. Now, looking at 28.1, where would that fall? That kind of a complaint?
That one would fall under section 28, subsection 1G, which is corruption. And why am I saying that? The facts of the case would then demonstrate to you that it is not necessarily theft in a literal sense. Yes, the person was deprived of ownership, but the manner in which it happened, there was some kind of misrepresentation in the process, and hence the matter is with us.
I think my emphasis was more on where, in terms of that subsection G, you say it is initiated by the executive director on his or her own, or after receipt of a complaint from a member of the public, or referred to the directorate by the minister, MEC, Secretary of Police. So it identifies, G identifies what triggers this corruption investigation.
Yes, very true.
And I think what I'm asking is, does this also permit, for example, the chief of police, because they're not specifically mentioned here?
Yes.
How does the jurisdiction of the IPID arise if a complaint of corruption is laid, say, by the chief of police or another police officer?
It does permit. It can be any other person. It can be any other member of the public. Yes.
Director will not say, well, you are not one of the people that are listed there with the power to complain, and therefore I don't have the jurisdiction to investigate.
True that.
Okay, thank you.
Thank you, Commissioner. Mr. Kefalakai, then we were, I think, turning to your paragraph 6.
Or section 29, this is the reporting obligations, commissioners, that the SAPS and the MPS, they are obligated to report to IPID as soon as they become aware of such matters that they are supposed to report to IPID. And failure to do so will then result to them be subjected to investigation for failure to report.
Please continue.
Okay, thanks. We expect that the station commander, any other member of the SAPS, any member of the MPS, meaning it doesn't really dictate as to the levels or the ranks of the members within these law enforcement agencies in terms of the reporting obligations. So as I've indicated on 6.2, what should be reported, I've indicated that it's all section 28.1 subsection A cases. I have just mentioned them one by one, commissioners. I do not know whether we should maybe go to the next paragraph because I've already alluded to those provisions of the Act.
Indeed, I would suggest we do so because you have spoken to the provisions of section 28.1, which is what you repeat, as I understand it, at your paragraph 6.2.
Yes.
So we have dealt with that.
Okay.
Okay. You conclude on that topic at page 4, paragraph 6.2.6, that a failure to comply with section 29 obligations constitutes a criminal offense. That's correct.
That's correct. That's in terms of section 33. Commissioners, to demonstrate that indeed this constitutes a criminal offense, we do have statistical data of cases that were opened and investigated by IPID by failure of the members within the law enforcement agencies to report or to refer such matters.
And if I understand your statement correctly, that criminal offense, however, can only be committed by the people you set out in paragraph 6, which is the station commander, a member of SAPS, and a member of the Metropolitan Police Services.
Correct, Commissioners.
Thank you. You then, from page 4, deal with what you call IPID standard operating procedures. Would you like to deal with that?
Thank you, Commissioners. With regard to the standard operating procedures, Commissioners, just to give a bit of a background with regard to our SOP or the standard operating procedures, as we do refer to them to, is that they emanate from the actual IPID Act. And then from the IPID Act, obviously there are regulations that would then serve to regulate how we should function within our environment. For a typical example would be how we should deal with each and every matter. Your case of death as a result of police action, that's basically what the regulations will then attempt, even the time frame, the turnaround time to complete a particular matter. So it is expressed in the regulations. Then from the two documents, the Act and the regulations, that's where now we operationalize this Act and the regulations through the standard operating procedures. And the standard operating procedures are more of a working document. They are more of a guideline as to how we should deal with our cases. And this SOP, they provide for the receipt, the registration, the processing, the referral, and the disposal of complaints and cases, meaning how we deal with the matter as we receive it until its finality. And then it also provides for case intake committee to review, determine, and allocate a case and to give directive on what is to be done in respect of each case. Meaning upon receipt of a complaint, there would be a committee that would sit, dissect this matter and say, this matter, looking at it, we think that it is within our mandate, or it is outside our mandate, or it's a matter that we might have to close it because it's miscellaneous. It doesn't really have substance at all. But it would be the committee sitting, talking to that. And the committee will also give directives and then allocate it to a specific investigator to deal with. And for the purpose of this submission, the IPID's process flow for managing complaints and cases is outlined below, noting that the process may vary depending on nature of complaint or case and includes the following. Why this statement is important is because what I have outlined here under is just, it is not for all the cases. It's not a panacea. It's not serves to address all the cases the same way. But I've just put this just to give context, particularly if we were to deal with a case of death as a result of police action, or where a person lost his life or her life as a result of the action of the police. Here I'm saying we re-attend the scene of the scene where the death occurred. Record details of the deceased, identify and record details of potential witnesses, authorize the removal of the corpse, collect exhibits and other evidentiary material, where necessary refer exhibits to the forensic lab, visit the deceased next of kin to inform them of the death. Very important that as and when someone has died, we have got the responsibility to go to the family and inform them that we are IPID. We have this information about the death of your loved one. And we visit and we interview witnesses, we obtain the statements, we attend the postmortem examination. After collecting all evidence and statements, we submit a report to the provincial head or the executive director, make a determination as to whether a member concerned must be arrested or not. If arrest is required, ensure it is carried out in compliance with the Section 39, Act 51 of 1977 of the Criminal Procedure Act and the SOP. So, in our case as IPID, we know most of our suspects are police members. And we know the kind of the environment the police are working under. So every time when they say the police have shot and killed 3 people, 4 people, we don't just go and arrest them, because there might be rationale behind why they have fired the shots. Because we have observed that in many instances, there would be a shootout between the police and the deceased persons. So we first investigate. Arrest to us is the last option. But there are instances where we effect an immediate arrest. And in the main, or it happens predominantly in instances wherein it's a femicide kind of killing. A man would kill his wife and the child. And there it does leave us with no option but to effect an immediate arrest. But in many instances, we regard arresting a police officer as the last option, because we still have time to investigate and gather facts, other than arresting the police officer on the spot and you investigate, only to find that you expose yourself to unnecessary litigations. So those are the things that we would then take into consideration. Now,
Sorry, before you you proceed. What you describe in paragraph 9, parts of it seem like a duplication of what the SAPS would do. For example, authorize the removal of the corpse. And I'm really asking you a practical question. 9.7, you say visit the deceased next of kin to inform them of the death. It seems like a duplication. In practice, how does it work, in fact?
In practice, and I would use death as a result of police action as an example.
Sorry, you'd use?
I'll use, as and when a person is killed by the police and they refer the matter to us, when it gets to us, we reclassify it as death as a result of police action. They would register it as murder, but when they refer to us, it changes its classification. Now, when there is such incident, the police would then immediately notify us. So we do have our investigators on standby 24/7. And as and when an incident occurs, they would then inform those that are on standby, and those that are on standby would then attend to the crime scene and ensure that all these activities are attended to. However, there are instances wherein it's a challenge for IPID. You have a province such as the Northern Cape, which is so vast that when we receive a matter now, the distance that we have to travel to attend to that murder case is 500 kilometers. Sometimes to drive from Kimberley to Port Nolloth, it would take us, it's just about 1,000 kilometers. And the police would then process the crime scene. And that's where independence gets compromised, because that's the reality on the ground now. Sometimes we get multiple murder cases almost at the same time, 3 cases, 3 different places. So those are some of the challenges that are there on the ground.
But I mean, from what I'm understanding, ideally, if things worked perfectly,
yes,
at every scene where there's been a death, let's say, IPID will be there together with the SAPS.
Very correct.
Okay. Thank you.
What happens is that, Commissioner, SAPS will cordon off, they will protect the crime scene. Let me use the simple language. They will protect the crime scene and then call IPID, that when IPID arrives, then they hand over the crime scene. But then they will then cooperate in terms of providing the background as to what happened and even giving some statements of what they have on their knowledge of what has transpired.
Thank you.
If I may follow up, I had some questions on paragraph 9 as well. Judging from the response you just gave to Commissioner Baloyi, you have listed at paragraph 9.5 and 9.6 processes that IPID undertakes following a death from conduct of a police officer. I'm interested in 9.5 and 9.6, particularly collect exhibits and other evidentiary material, and 9.6, where necessary, refer exhibits to the forensic laboratory. My question is, and again, judging from the response you gave Commissioner Baloyi, is it your testimony that where the perpetrator is a police officer, that SAPS relinquishes its duty regarding collection of evidence and the chain of custody, and that is assumed by IPID, or not necessarily? What happens there?
In this instance, IPID does not have experts to collect certain evidence, especially the latent evidence. You know, some of the evidence you can't see with your naked eyes. Hence, we would then rely on the SAPS to collect such on our behalf. And with regard to the exhibits having been to be preserved, we follow the due process following the how SAPS would, we would take the exhibits to the very SAPS because they need to be processed accordingly, book them in the so-called SAP 13. The SAP 13 register, of course, it's a property exhibit register. So we'll book them in there, and then we will still refer them to the SAPS Forensic Science Laboratory for analysis because we do not have the capacity. We do not have the financial muscles. But I want to also point out that in terms of that process, it's in very few cases where we would have problems about the work that would have been done by the lab from the SAPS, wherein we would have a problem of the integrity of the information. We do not doubt their integrity and their potential in assisting us in this regard, and we do have cooperation. The only challenge that we would have is the delay sometimes because, you know, the lab would be so much overloaded with backlog and so on and so on. It's a matter that affects all the entities, your SAPS themselves, your DPCI. So it's not a unique thing to IPID. But when we write to them and say they should prioritize a particular matter, they do cooperate and assist us for the purpose of prosecution. Thank you, Commissioners.
Thank you, Mr. Kifelakai. I think that takes us to your paragraph 10, where you introduce the requirements of Section 7 of the IPID Act.
Okay, thank you. In terms of, on paragraph 10, Section 7 of the IPID Act makes provision for the referral of recommendation to the national or relevant provincial commissioner. SAPS must initiate disciplinary proceedings within 30 days and report to the minister and copy of the secretary and the IPID, which then would refer to the executive director. We also file quarterly reports, progress to the minister, and copies to the secretary. That's with regard to the recommendations. And yes. I want us to take cognizance to the fact that SAPS must initiate disciplinary proceedings within 30 days. But I did not give expression to the MPS. Then that would then take us to paragraph 11.
Well, before you do so, you specifically point out that at paragraph 10.1.1, that requirement to initiate disciplinary proceedings within 30 days is in relation to SAPS. What is the legal position regarding Metropolitan Police Departments? Is there a similar requirement, and if so, where is to be found?
Commissioners, and that's something that I'm going to elaborate on paragraph 11. There has been the legal lacuna in that regard, that the Act does not, the current Act, IPID Act 1 of 2011, does not give expression with regard to the municipal police services insofar as the recommendations are concerned. And that created some kind of frustrations because once there is a legal gap, anybody can take advantage of that. And that led to some frustrations wherein some of the recommendations seem to have been ignored or rather, there were concerns that I will speak to at a later stage with regard to some of those recommendations, particularly by the Municipal Police Service.
Thank you. You may proceed.
Yeah, on paragraph 11, Commissioners, implementation of recommendation made by IPID is inconsistent, particularly within Metro Police Department. The IPID Act 1 of 2011 does not prescribe processes for the handling of negative recommendations requiring disciplinary action against transgressing members. Combined with inconsistent reporting lines across Metropolitan Council, the gap undermines accountability and the reinforcement of IPID recommendations.
Yes.
Yeah, Commissioners, this is a challenge that with SAPS we expect SAPS to initiate within 30 days because it's clear, it's in the law. But with the MPS, there is nothing. However, I want to point out that, and it's there in paragraph 13, which will then serve to address the legal lacuna that I have just alluded to, if I'm allowed to do so.
Indeed, you are, sir.
Yeah. Let me first read paragraph 12. Furthermore, the municipal police would enforce a uniform code of conduct applicable to all employees, including sworn police officers. If you have the type of disciplinary code of conduct that serves to address disciplinary issues for all employees, including the police, the municipal police service within a particular municipality, it becomes a challenge because you want to treat, and it has been the practice that treating the serious matters committed by the municipal police the same way as you do with those of a draftsman, a gardener, a cleaner. I'm not saying cleaners I'm not trying to be condescending, but I'm trying to express the fact that police are highly regarded as people with some kind of responsibilities, and they need to conduct themselves in a particular way. There is a standard that is set for them, considering their role in terms of their conditions of their establishment. That they should prevent the crime, that they should enforce the bylaws, that they should deal with issues of traffic. But if they do something very contrary to that, that then becomes a problem. Then you want to discipline that person the same way that you discipline the person who failed to clean up the toilet on a particular day. That then is quite a remiss, Commissioners.
Mr. Pelakai, one of the issues that arose, I think it was also in the statement of a witness we heard from in the last 2 days, is that where IPID has referred or has recommended that a police officer be disciplined, but at the same time, you've referred the case to the NPA for prosecution. The municipality says the matter is sub judice, therefore we cannot act against this officer. So they will remain in the force until the courts determine whether they are guilty or innocent. And the municipality will only act after the court has said this person is guilty of a crime or not. You can just address that as best as you can.
Yeah, with regard to that part, it's very much easier with the South African Police Service because they are highly regulated, and their disciplinary regulations are very clear. I'm not saying they're perfect. We have identified gaps here and there which are being addressed. But now, when the matter is reported, IPID cannot refer a matter to NPA for decision to decide on prosecution without referring the recommendations which are negative. Negative recommendations means wherein we are saying we have investigated and we have found that there is a case to be answered by your member or members. So it's a process that would run concurrently. The day we send to the NPA is the day we send to the municipality. So much as the test is different, that it will be on the balance of probability on the one side and beyond reasonable of doubt on the other side, but the process, we make sure that it runs concurrently. Yes, there are instances wherein we would send only recommendations to the SAPS to take steps against their members because we cannot find any criminal element on a particular matter. Same with the municipality for them to take actions. So it is a serious excuse that the matter is sub judice, that we have referred the matter for criminal prosecution. That I don't know where it comes from. That could be just an excuse. There are instances, of course, where you would find that in the SAPS in particular, when they have to institute their disciplinary actions, we arrest the person today. As we are trying to investigate, they then institute what they refer to as expeditious process. That's where now within a week the person is dismissed. Is no longer the member of the South African Police Service because the matter is serious. They cannot sit with somebody who is a criminal within their establishment. So that we know that it does happen. But with this excuse, I think it could only be from the municipality. Now,
before you proceed, I agree with you that it's an opportunistic excuse.
Yes.
That is offered there. But coming back to the recommendation to institute, in fact, we've seen it in a report or something from the IPID to a municipality.
Yes.
It being, in fact, more than a recommendation, it directs that disciplinary action should be taken. Now, and then it says you must then report when you finalize it and then report back to IPID so that we can report, we can do our report to the minister or something. Now, if you don't, what happens if they don't comply? What does IPID do? And I see you say the law, there's a lacuna in the law. I'm more interested in practically on a day-to-day basis, because there's no point in having this provision that says they have an obligation to conduct disciplinary proceedings where you've recommended or directed that. And if they don't, that's the end of the matter. Or you just file a report to the minister to say, well, they haven't done anything about it. What practically is the consequence? What do you do as IPID?
Thanks, commissioners. Commissioners, when we started in 2012, 1st April, the 1st of April 2012, there were terms of reference that were developed that this is the way in which we are going to cooperate with the stakeholders. And they are very clear in terms of because we also acknowledged the legal lacuna like I indicated earlier. Subsequent to that, there was an MOU that was signed with all the metros and the SAPS that we do agree that we will deal with these matters in this particular manner, in a way in we will, IPID will send the recommendations to the stakeholders. SAPS, we will initiate within 30 days. And then we will make sure that we provide you with feedback, the outcome, and all of that. And because they knew that the Act makes provision for that. And in the main, they are doing that. And then you have the Municipal Police Service, wherein they comply, they do that. But you sometimes have a concern that this application of this MOU and the terms of reference seem to choose as to where to apply. I think in this document, Commissioners, there is a part where I've made reference to a specific matter. But all that I'm saying is that with regard to other members, we see actions being taken. But then it's surprising that there are those that are immune, seem to be immune. And you also observe some kind of political interference, if I to put it.
What does IPID do with that? I mean, and I think it speaks more to, you see, you in the earlier sections of the statement, you've told us that there is an obligation, there's a reporting obligation, and it's a criminal offense not to report. I think that if you don't comply with Section 29, I think it's
correct, yes. Commissioners.
And it's an offense failure to comply. Now, it seems to me that it defeats this part. If you make recommendations for action to be taken, nothing is done, and you don't have the power to do anything about it, which means the SAPS or the MPS are free to decide. As you say, you end up with these inconsistencies. And if there's nothing that IPID can do about it, because there's no compelling mechanism where you can compare, where people could be disciplined for failing to take action in accordance with IPID, then it's defeating of what looks good on paper, which is we instruct them to comply within 30 days. But that's the end of it, because you don't have the power to do anything about it. How is that managed, and is there any plan, intention to address that? And it takes, it reminds one of that old debate about the powers of the public protector, where a recommendation is made and then some people understand them to be, I can comply. If I don't comply, that's the end of the matter. No one can do anything about it. I can choose to do what I want.
Thank you, Commissioners. I think I should have responded better to this question from the beginning. As I've indicated, that with SAPS, we do not have a problem at all. We know that we do have a leg to stand on as a department. They know the 30 days, and there is a consultative forum that happens every quarter with the Civilian Secretariat Act for Police, because in terms of the Secretariat Act 2 of 2011, one of their responsibilities in terms of the Act is that they need to monitor the SAPS or the SAPS on the implementation of the IPID Act. So basically, the extent to which SAPS is able to implement the SAPS, the IPID recommendations referred to SAPS, but it's very silent about those that are referred to MPS. That is what would then the commissioner asked, what are you doing? What we did with some of the cases wherein we were frustrated by the municipal police services, we then rolled through the executive director to remind the city manager that we are being frustrated here. We have referred the matter which you have received on a particular day and month and year, and you are quiet. And when there was no response in that regard, we further went in person now to meet up with the MMC and the mayor at the time to say we are frustrated here. We have sent these recommendations, but there is no feedback. We are concerned. Are you able to intervene? They promised that they will intervene, and we gave the document. There was no intervention. So then we had to go back and see, but then what would then be the next recourse? And we were actually trying to find ways, but we then later learned that, and especially after after the establishment of this commission, that we started to see the action, and a serious one for that matter. And even some of the lies started coming out. Our names were dropped and all of that, with all the lies that no, but we have informed, especially myself. There was a document that was on the media saying that I have received a document, but I have reliably been informed that actually that was just another fraud that was committed within a particular of that in that specific municipality.
So that's fine. You do escalate to the political principles with municipalities.
Yes.
I think that's the kind of answer I was looking for.
Okay, thank you.
But maybe lastly, have you given thought to whether it should not be made an offense to fail to comply with the recommendations of the IPID to institute disciplinary proceedings? Has there been that kind of discussion, and would it be something that you would consider as useful and helpful to give effect to the recommendations of the IPID? And here I'm thinking. And if, for example, you direct your recommendation, you would direct the recommendation, as you say here, to the city manager or the executive municipal manager, I think that's what they would be called. So that's who you direct to make sure that there is compliance with your recommendation. And then you back that up with a stick, which says, if that is not implemented, the law makes it an offense to fail to abide the recommendation. Have you considered that as IPID, and is it something that you would give consideration to?
Thanks, Commissioners. Commissioners, that process has already unfolded. Following all those challenges, and of course with some, the IPID Amendment Act 15 of 24 has been considered, and at this stage, the proclamation has been made partly by the President, with the remaining 5 clauses that needs to be proclaimed. And currently, the gazetting of the regulations is at advanced stage, and upon the conclusion of such, we would then be able to have subverted or circumvented this problem, because now it is very clear in the law that the municipal manager now will take the responsibility of accounting to the implementation of these disciplinary recommendations.
Thank you. Thank you, Mr.
Thank you, Commissioner. Mr. Kiafela, perhaps let's just take it a step further. And in relation to your paragraph 10.1.1, the 30-day period within which SAPS must implement the engagement you had with Commissioner Baloyi, I think I understood your answer. Is that directive binding on SAPS, firstly, to your understanding? And what would be the consequences? I appreciate the fact that you say that you don't get challenges with SAPS insofar as compliance is concerned. But in the event that SAPS were to fail to comply with what you have set out in 10.1.1, what would be the consequences, do you know, for SAPS?
Thanks, Commissioners. In terms of SAPS, the law, it's very clear that non-compliance would lead to cases being opened. And however, the initiation within 30 days is managed carefully between SAPS and IPID, and there are monthly meetings that are taking place even in provinces wherein recommendations are being discussed. And that meeting is chaired by the Civilian Secretariat for Police Service, and we are able to track progress on each and every case.
Yes, my question is, but you're saying that the Act provides that non-compliance would attract adverse consequences for SAPS.
Yes.
That is how the law provides.
That's how the law provides,
Okay.
Commissioners. Yeah.
Now, the Amendment Act you reference at paragraph 13, as we have understood the evidence thus far, IPID in terms of the 2011 Act does not have power and authority over municipal police services. The old Act as it stood, 2011, that IPID assumed power over MPS through the MOU that was signed.
That's true, Commissioners.
And as we understand it, that Amendment Act of 2024 seeks to legislate precisely what is currently managed in terms of the MOU.
That's correct.
Now, what's your understanding of, two questions for me, that Amendment Act, would it extend the consequences for non-compliance to the municipal manager, same as they would apply to SAPS?
Precisely.
And secondly, our understanding was that that Amendment Act has come into force in part. Some parts are yet to come into force. Specifically as regards this issue, do you know whether the Act has come into force?
Not yet, Commissioners. Is those areas that are being dealt with currently to try and expedite the regulations.
Okay.
They've been published. At the moment, we envisage, Commissioners, that perhaps by Q2, which is August, thereabouts, we should be ready. By then, we believe that all the processes would have unfolded and the implementation of this Amendment Act would have kicked in. Thank you.
Yes, Chair.
Thank you. I have a related but slightly different issue. Say a recommendation is made for disciplinary proceedings to be initiated. And say SAPS or indeed the MPS is not reluctant to act in accordance with the recommendation, but that when they look closely at the matter, they themselves are not satisfied that there is a case to discipline the person concerned. I would assume that it should be open to them to say there is no case here. I'm asking this in the light of 10.1.1 that says SAPS must the operative word here being must, initiate disciplinary proceedings within 30 days. So would it be perfectly within their remit to say there is no case for disciplining this person here? And if that would be open to them to say so, how must we read the must in your 10.1.1?
Okay, thanks.
I hope I'm making sense.
You do, Commissioner, and I'll respond to that. I understood the question. Yeah, the 30 days it's for initiation. Initiation, which then means they should have appointed the functionary, the investigator, and so on and so on. That's the 30 days to do all of that. And then they need to then say to us, now we have appointed this investigator, he's dealing with this matter. So they can't come to us within 30 days and say, we don't see the case here. There is no case, because we would have investigated and made negative recommendations as opposed to positive recommendations. And I want to point out something, that there are two types of recommendations: the positive recommendations and the negative recommendations. And the word negative, I think it explains itself. It means bad, it means red. So the positive means we have investigated this matter thoroughly. And after investigating this matter, we have found out that there is nothing wrong on the part of the police. And I want to say that in majority of our cases that we complete, we establish or we uncover that the police would have acted within the limits of the law. But then you would find in a few of those cases where then we would find that indeed there is substance, there is a case to answer. But 30 days is for initiation.
Also, the answer turns on an interpretation of initiate.
Okay, yes.
Thank you.
Did you want to?
Yeah, please, Commissioner.
Yes. That initiate, just to further understand it, you speak of the initiate by conducting an investigation. So they start something. So there's an investigation and there is an initiate, which is to appoint a chairperson of a disciplinary hearing. Until your explanation now, I understood, my impression was that once you've given this directive recommendation, what it means is the employer, SAPS or MPS, they don't have an option. They must now appoint a chairperson to run a disciplinary hearing. Is that a correct understanding?
Chairperson, it is supposed to be like that. However, there is this other challenge that exists, although it's not as big, but it has been raised with the Secretariat for Police as the people that are responsible to review these policies for our cluster or the ministry. Now, we do experience some challenges wherein we generate we investigate. IPID investigate thoroughly and make recommendations that disciplinary steps must be taken. But SAPS, they've got their own disciplinary regulations of 2017. That requires of the person who is appointed as an investigator. Then they would then reinvestigate the matter that has already been investigated by IPID. That is the practice. And IPID has raised some concerns with regard to that, and hence the process to then review the disciplinary regulations of the SAPS. The challenge with that is that a person who is just a cleaner wherever in who saw whatever occurred on a day in question when the crime was committed by the police and all of that. He's so confident that this matter is dealt with by IPID. And all of a sudden there is a man in blue uniform coming to say, I want your statement. This person now starts to ask, but now what's happening? So that's where now you realize that we start having these recalcitrant witnesses, because now they feel threatened. And if it's a foreigner, you won't see him again. He will flee the country because he has lost the confidence. I mean, SAPS has lost the confidence of this person. Because of the actions that this person have seen, and now you send another SAPS members, but as far as the person is concerned, he knows that the matter is sitting with IPID. So those are the challenges that we are actually working on. The process has already unfolded. And I believe that would be the remedy for this problem.
Thank you, Commissioner. Still staying with paragraph 10.1.1, and I would like you to consider my question in the context of SAPS. Let's keep MPS out for the moment. The report that must then be filed to the Minister and the Secretary of Police and IPID. What does that report traditionally contain? What does it speak to? Does it speak to initiation? Does it speak to outcome of a process? What does it traditionally speak to, that report?
The Section 7 report would contain the statistical data on the number of cases that would have been initiated on a particular period, the number of...
apologies, Mr. Kifelaka. Please have regard to paragraph 10.1.1. You state the SAPS must initiate disciplinary proceedings within 30 days and report to the Minister. I take it that the report is in relation to the referral.
Yes,
now,
that's
it's
correct.
That particular report, not the general reporting that is done to the Minister. In terms of Section 7 of IPID Act, the report that is then filed with the Minister and the Secretary of Police after the initiation of the disciplinary proceedings. What does it normally deal with, that report, if you are aware? Thanks.
Yes, I'm aware. Hence, I'm saying it is the kind of report wherein it would contain the statistical data of the initiations that would have happened in the SAPS in a particular period, as well as in the MPS. It would give the breakdown of statistical data of the initiation, just to demonstrate that indeed the recommendations are being dealt with.
Okay, so it's not a report on the specific matter.
It is not a report on a specific matter because it's not even detailed. It's more of statistics.
Yes.
The one that would then talk to specifics, it would be then the other report, that is Section 9N report.
Okay.
That would then break down.
Mr. Kifelaka, my understanding of the question is that the report is not a report on each individual case that was referred.
Correct.
So it is a statistical report covering what has happened during a particular period, so during a particular month. It's like a monthly or quarterly report of all the cases.
Very correct.
Okay.
Yes.
Thank you, Commissioner. Thank you, Mr. Kifalakai. Clear. And then perhaps I said lastly, but lastly, does IPID have means of establishing formally whether or not its recommendations have been dealt with, or its directives have been addressed by MPS or SAPS? Is there a consistent reporting to yourselves, or is that the Section 30 process that you reference, the monthly, quarterly statistical reporting?
Okay, thanks, Elsie. That question, what happens, there is any control mechanisms that are in place. There are monthly forums that are taking place between SAPS and the Metropolis together with IPID and the Secretariat. And in that meeting, that's where all the recommendations that have been referred are discussed, looking at the date, the time, and so on, to say, but we have referred this much to you, and specifically this, but we haven't received anything in terms of initiation. We haven't received the outcomes in relation to this. Where are the challenges? So they are discussed on a monthly basis. So that then serves to alleviate the much of the problem. It minimizes the challenges that we have, because much as there are delays, but you would also take note of the fact that then that's where we get to understand the challenges with regard to some of these delays on some of the matters. So the forums are serving as very good, and such reports from the provinces are then cascaded, rather elevated to national office. And once they get to national office, SAPS will intervene into their members. But we also have the consultative forum that sits quarterly with the Secretariat of the Police as part of their mandate, wherein we would then discuss those issues that then need the intervention of the Secretariat in terms of their act.
Now, as a matter of interest, and based on your answer, would I be correct then to assume that, insofar at least Ekurhuleni is concerned, that there should be some records somewhere within IPID on what specifically was discussed at these monthly meetings? Because I understood you to say it's between SAPS, IPID, and MPS, insofar as Ekurhuleni referrals are concerned, and the outcomes of such discussions. There would be a record of such deliberation within IPID. Would I be correct to conclude?
Commissioners, there are records, monthly records, and there is within IPID a program or a unit that focuses on the meetings that take place, and also to further demonstrate that is part of the IPID annual performance plan. So every month, every province must have that meeting. It doesn't happen that such a meeting does not happen in a particular province, because it's part of the annual performance plan. And to some extent, that then assists.
Okay.
Yes.
Thank you. Well, we did hold you up a bit on that part of your statement, but I think now we are at page 6, and I think we are ready to deal with your next chapter, which you've titled IPID Workload Overview, Key Statistics. If you could summarize for us what you have in the next 3 pages dealing with these statistics. Thank you.
Okay. Thanks very much, Commissioners. in this regard is the workload that IPID is having. The backlog cases, we are talking about these old cases, we are sitting at 11,947. And we have got the active cases that were still under as at the end of December 2025. We were sitting with 2,456. And the trend, Chairperson, is that come the end of the financial year, we would be having 14,000 of the cases that are still active. They still needs investigation. The investigation is not completed. And then the more we try to complete this backlog cases, this number of backlog cases then populate the post-decision monitoring cases. The more we complete our investigation, take the matters to the stakeholders, such as your SAPS, to discipline their members, metros and the NPA. Then we balloon the number of those cases that then we refer to them as post-decision monitoring cases, because we have completed them. Now they are going to and from court. They require subpoenas. You have to then transport this witness from point A to point B because he's scared. He cannot go there by himself and all of that. So those are the challenges that we are having. So that would be the post-decision monitoring cases. In total, we were sitting with 48,432 cases. But now, of this 482 cases, 32 cases, we only have 182 investigators countrywide. Now, on average, I'm saying here that one IPID investigator will be sitting with 266 cases. And now, I just want to run through with table 1. I'm not going to stay long there, just with Gauteng only.
Before you do that,
okay.
In 14.1, that case backlog of 11,947 as at 31 December 2025, that's 14.1?
Yes.
That 11,947 cases, what is the age analysis of it, if you've done that? Because
yes, I would have the age analysis of these cases. I think at the time for 2018 and older, it was just above 2,000. And if I were to be allowed to go to
you don't have to do it now.
Okay.
I'll leave it to Ms. Silla how she wants to
we will locate it in the annex during tea time. Then you'll deal with it then.
All right. So when you do discuss it, it's the age analysis, but also the fact, what is in fact contained in that backlog, because there may be a backlog because you have only 182 investigators, but there may also be cases that are backlogged because you don't have access to witnesses, because of, you understand what I'm saying? Maybe a function of you're investigating problems related to investigating, and therefore you're unable to finalize cases. If you could just distinguish those as well.
Okay.
Thanks, Ms. Sil.
Thank you, Commissioner. We shall attend that to that during tea time, Mr. Kefalagai, and we will locate it in your annexure 1. You confirm? Do you confirm, Mr. Kefalagai, that that information is contained in your annexure 1?
Yes.
And then we'll deal with that during tea.
Okay.
You may then proceed, I think, to deal with your table 1, which is what is projected on the screen.
Thanks, Commissioners. On table 1 is the breakdown per provinces in terms of the total workload, the 48,432. the total investigators, and the number of investigators in each province. And then on the side, it will then give a clear average caseload in the respective provinces. If you look at Gauteng, commissioners, Gauteng on average is sitting at 390. That's out of 32 investigators. And this can also be attributable to the fact that the intake in Gauteng province is very high. And I think it's also compounded by the fact that we receive death cases. If it's not daily, it will just after a day you get a death case. Sometimes you get 2 in one day. And sometimes in one incident, it's 4 bodies. It is even worse if we were to go to the statistics of death cases. The average at the time, if you were to look into Gauteng only, one investigator would be carrying 43 death cases. But that would be nothing compared to KwaZulu-Natal. Not just in terms of number of death cases, but the dead bodies. Those are some of the challenges. But quite interestingly, when you look at this stats.
So what you are saying is, even though Gauteng is 390 and KwaZulu-Natal is 325, but death cases in KwaZulu-Natal are more.
Very true.
Compared to death cases in Gauteng.
Very true. The point that I wanted to just raise is that when you see a number of cases in Gauteng, or IPID having a high number of cases in Gauteng, there is a correlation between what is happening in our communities and what we are having. You will find that if SAPS has got a high number of death cases, IPID will automatically have such. So the observation is that the communities out there, they are also not too kind. If you look at the atrocities that they're committing, it's worrying because they force the police to go and act in many of these cases. Because the police, they've got no choice, but if they hear that there is robbery in progress, there is residential robbery in progress, there is hijacking in progress, they will respond promptly. When they get there, they are met with fire. And that then generates a lot of death cases. Same with any other classification. So that's where we are having a problem, that the problem when you analyze the crime, you realize that there is a correlation of what IPID is happening and what is happening on the ground. When you see more cases of death on the ground in KZN, you must know that the community is there as well. They are very dangerous. They are carrying dangerous weapons. And those are some of the challenges which I think I should then explain so that there is a rationale in terms of these statistics.
Before you step off Gauteng, but perhaps even after you've stepped off, because my question, I think, relates to all the provinces. I want you to discuss as fully as possible how practical it is for each investigator to deal with the averages you are giving us here. Eastern Cape 289 per investigator on average, all the way down to Western Cape 288, and then the national average of 266. how practical is it for each investigator to deal with those numbers? Perhaps that's something you can deal with after tea.
Okay.
Let's adjourn and come back at 11:20.
Thank you, Chair.